Welcome to video presentation 5 for criminal law. This video presentation will discuss mistake of fact and law. To begin with, I'm going to look at a couple of examples to sort of set the stage for what we're going to do. So in this first slide we have our perpetrator here there and saying to himself, there is my computer, I'm going to take it to my class. And our hapless fellow picks up the computer and walks away with it. When he is out in the hall, he turns it over and he discovers, oh, this isn't my computer, it belongs to Professor Guttenberg. So what we have here, he has made a mistake of fact as to the ownership of the computer. Our question is he guilty of larceny? That is, the trespassory taking and carrying away the property of another with the intent to permanently deprive them thereof. Another example. Boy, am I tired. Sure glad I'm home and John left the door open for me. He walks inside. Dang, this isn't my house. This is Wilma's next door. They sure look the same from the outside. Again, the question becomes mistake of fact as to whose house he is entering, and is he guilty therefore of trespassing when he has entered the wrong house. So let's start to take a look at how we're going to evaluate mistake of fact at common law. There were two different treatments depending on the type of crime. Remember, I told you that we would come back and revisit specific intent crimes and general intent crimes. Well, this is one of those opportunities to do that. So the treatment of mistake of fact at common law depended on the type of crime, whether it was a general intent crime, whether it was a specific intent crime. So let's go back and do just a quick review of what is a general intent crime and what is a specific intent crime. So specific intent crimes, if you remember, we talked about they required an additional mens rea beyond that required for the actus reus and attendant circumstances. An example would be theft. Here, the elements of theft are the trespassory taking and carrying away of the personal property of another with the intent to steal the property. So what we have here is the actus reus is the taking and carrying away. The attendant circumstances are the personal property of another. But in this instance, highlighted in red, we have an additional mens rea required on top of those required for the actus reus and the attendant circumstances. That makes this offense a specific intent offense. With general intent crimes, there is no additional mens rea beyond that required for the actus reus and the attendant circumstances. Let's take another example, rape. It's the sexual intercourse by a male with a female, not his wife, without her consent. In this instance, all of the actus reus and attendant circumstance elements have a culpability or mens rea that would be required for them, but there is no additional mens rea required. Therefore, this offense is a general intent offense. Now, as I said, at common law, how mistake of fact was applied depended on whether the offense was a general intent or a specific intent offense. For a specific intent, we evaluated the mistake of fact, the fact that the computer wasn't was somebody else's, the fact that he entered the wrong house. If it's a specific intent offense, it gets evaluated by honest belief. That is a subjective belief of the defendant. If it is a general intent offense, it gets evaluated as to whether that belief, that mistake, is reasonable and honest. This is an objective and subjective belief. The jury would be asked, if it's specific intent, to determine did the defendant have an honest subjective belief. For a general intent crime, the jury would ask or would be told to determine whether that mistake was both honest, like the specific intent evaluation, and additionally whether that mistake was reasonable. And if the jury determined that even though the defendant honestly believed it, if that mistake was not reasonable, they would find the defendant guilty, and that would prove the offense. So let's go back and look at our examples. Dang, this isn't my house. Remember, this was the mistake of fact as to entering the wrong house. Again, mistake as to whose house he is entering. Is he guilty of trespassing? Well, now what we would have to do is to determine if trespassing is a specific intent or general intent offense. So we would take a look at trespassing, the wrongful interference with the real property of another. So the question becomes, is this a general intent or specific intent offense? Notice that there is only culpability or nothing else beyond the elements, the actus reus and attendant circumstance elements of this offense. So the question, general intent or specific intent? This is a general intent offense. Therefore, the mistake as to entering the wrong house would be tested by, is this an honest and reasonable belief that the house was his and therefore not wrongful and not property of another? Again, now back to the computer, taking the wrong computer. This isn't my computer, it belongs to Professor Guttenberg. So now the determination is mistake of fact as to ownership of the computer. Is he guilty of larceny? Well, larceny was the trespassory taking and carrying away the property of another with the intent to deprive them thereof. And if you remembered, larceny involved an added element, this intent to deprive them thereof. So as a result of that added element, on top of what is needed for the taking and carrying away, which would be the actus reus elements, and the property of another, which would be an attendant circumstance, we have this additional element of intent to deprive them thereof. That makes this a specific intent offense. As a result, the evaluation of taking somebody else's computer, taking the computer believing it was his, would be an honest belief that property was his, and no intent to deprive. The evaluation the jury would engage in is, was this an honest belief? The Model Penal Code handles this slightly differently. And as you know, the Model Penal Code does not involve a distinction between general intent or specific intent crimes. There is no such distinction in the Model Penal Code. And in fact, what the Model Penal Code does is it ties the ignorance or mistake directly to the culpability elements. So does the ignorance or mistake negative the purpose, knowing, recklessness, or negligence required to establish a material element? So here the inquiry is directly into what is required for the culpability. This isn't my computer, it belongs to Professor Guttenberg. Again, our hapless computer taker. So now the question becomes mistake of fact as to ownership of the computer and guilty of MPC theft. So we have to look to see the elements of the Model Penal Code theft, which is the unlawfully takes movable property of another with the purpose to deprive him thereof. We're going to talk about this in class, but in advance of class, I want you to think about how you would set this offense up. What is the culpability required for each element, and how would the mistake as to whose computer it is be evaluated under those levels of culpability? So we have, this, I want you to analyze the statute. I want you to determine the culpability for each element and think about how mistake of fact plays out with respect to each element of the offense, and we will talk about this in class. Let's talk about mistake of law for just a brief moment. We have the old axiom, ignorance of the law is no excuse. The same thing, lack of knowledge of the law is no excuse. At common law in today, a defendant does not have to know that what they are doing is illegal. All they have to do is the elements that are required. They have to engage in the actus reus, they have to engage in the attendant circumstances, and they have to have the appropriate levels of mens rea or culpability. They do not have to know that the sum total of all of that is against the law. This is not required, so they don't have to know that taking somebody else's computer is against the law. As long as they take and carry away the property of another with the intent to permanently deprive, they are guilty even though they have no clue that that is against the law. So, as I said, mistake of law is a defense, though, where the statute expressly makes knowledge of an element a crime. So an example that Dressler uses in his book is campaign finance law that makes it an offense to knowingly violate the law. In that instance, you would have to know that certain campaigns finance laws make certain conduct illegal. Their knowledge of the law is written into the law itself by requiring a knowing violation. Mistake of law is a defense if the mistake as to the legal status or application of the law negates the specific intent required for the crime. So it could be a defense to specific intent crimes, but it's not a defense to general intent crimes, but only if it negates the specific intent of the crime. We'll talk more about this in class to try and clarify it. And it's generally a defense only when there must be knowledge of the law or certain legal status in order to convict. But this is really rare. This is not going to happen very often. So knowledge that one is legally married could be an example of this. Knowledge of that one is one's wife could be another example of this. But again, it's going to determine on whether the offenses charged are specific intent offenses or general intent offenses. We again will talk about this in class. This brings us to the conclusion of this short video. You are reminded to go to Twin and do the assessment for the video by 12 o'clock noon of the day that the video is to be viewed for class. Thank you.